Hello everyone. In a landmark move, the Supreme Court has upheld the judgment of the Gujarat High Court in the case of Mohit Minerals. In this judgment, the Supreme Court has held that there can be no levy of GST on an ocean freight transaction. In this video, we'll be analyzing the correctness of the reasoning adopted by the Supreme Court in holding that there can be no levy of IGST on an ocean freight transaction. Given this, we'll proceed to determine how the transaction is undertaken, as also the issue involved before the Supreme Court. The transaction is undertaken between two parties, that is importer and the foreign supplier. The importer enters into a contract with the foreign supplier for supply of goods on CIF basis, that is, the responsibility of delivering the goods is still the custom stations in India. Further, the cost of the goods also includes the insurance and freight element as well. In this case, foreign supplier engages a shipping company which is also located outside India. The shipping company raises an invoice upon the foreign supplier, and the foreign supplier directly pays to the shipping company, and there is no privity of contract between the shipping company and the importer concerned. When the goods reach India at the customs station, the importer pays customs duty on the entire value that includes insurance and freight element as well. In context of GST, Section 5.3 forms the relevant provision for determination. Section 5.3 empowers central government to notify the services, the tax on supply of which shall be payable under reverse charge. In exercise of the powers granted under Section 5.3, notification number 10 was issued by the central government, where the central government designated importer as the person liable to pay service tax on ocean freight services. And notification 8 prescribed a rate of 5% on the said ocean freight services. Thus, this dispute involves that when Section 5.3 allows only a recipient of the transaction to pay tax on under reverse charge mechanism, whether notification designating importer as the recipient is a correct position of law, and whether such notification designating an importer as the recipient is ultra vires of the Section 5.3 or not. The notification designating importer as the recipient was put to challenge before the Gujarat High Court in the case of Mohit Minerals. The Gujarat High Court in its judgment held that importer is not the recipient, as the privity of contract is between the foreign supplier and the foreign shipping line itself. Further, Section 5.3 forms part of the charging provision itself, which should be read very strictly. If on the strict interpretation of Section 5.3, anybody apart from the recipient as such cannot be designated as a recipient. In this case, the importer being designated as recipient is ultra vires the provisions of Section 5.3. Moving on, Article 265 provides for levy and collection of tax by authority of law alone. However, imposing a tax on importer through a notification is bad in law, and therefore it is beyond Article 265 as such. Further, there are no provisions for determination of time and value of supply, as those provisions are worded qua the recipient itself and not any other person. In addition to this, ITC is also available only to the recipients of supply, and importer is not the recipients of supply, and therefore the notification is further ultra vires. Further, the Gujarat High Court noted that the goods along with insurance and freight elements suffers customs duty when it is imported into India. Further, a levy of GST on the transportation aspect yet again would lead to a double levy, which is against the settled principles of law. And therefore, the notifications were held to be ultra vires of Section 5.3 as such. Thereafter, the issue reached before the Supreme Court when the department filed an appeal against the Mohit Minerals judgment of Gujarat High Court. The Supreme Court has examined the issue and held that essential functions have not been delegated to the central government. That is to say, levy of tax has 4 pillars: taxable event, person liable to pay tax, valuations of supply, and rate of tax. All these issues, all these pillars have already been notified in the Act itself, and any further notification designating importer as recipient is only clarificatory in nature. Therefore, the notification are intra vires and not ultra vires as such. The Supreme Court held that importer is a recipient as such because of two reasons. One, that the place of supply of transportation service is determinable in terms of section 13(9), which happens to be destination of the goods, which is India, and section 293 of the CGST Act, which defines recipient, provides for any person to whom supply is made also to be a recipient in such cases. Source of power to notify importer as recipient traces to section 5(4) of the IGST Act, which expands the scope of recipient as such, and therefore again the notifications are not ultra vires of section 5(3) as such. Further, there is sufficient territorial nexus in such cases because the goods are reaching India and the consumption is also being done in India by the Indian importer as such. Supreme Court held that levy of GST on service portion will violate concept of composite supply. So to say that once the imported goods have suffered customs duty on the value inclusive of freight element, then it cannot be subjected to GST separately again under the IGST Act as such. While the ruling appears to be correct, the Supreme Court has adopted such reasonings which has left various academic questions open for deliberation by the industry at large. In our view, Section 5(3) merits strict interpretation. Therefore, any other person apart from the recipient as such cannot be termed as recipient. In this case, the importer was not the recipient of the supply. Therefore, arriving at a conclusion by referring to place of supply and recipient definition is incorrect as such. Further, Section 5(4) does not expand scope of recipient as such, as the provision itself is worded in such a manner that the central government can only notify recipients of supply from an unregistered person and not any other person. Further, the reasoning adopted by the Supreme Court to the extent that the transaction qualifies as composite supply is also incorrect, as the CIF contracts are for a single supply and the cost of goods also includes cost of freight. In addition to this, the term composite supply, as defined under the CGST Act under Section 2 Clause 30, provides for supply made by a taxable person to a recipient. Here, there are multiple suppliers and multiple recipients in such cases. Therefore, the concept of composite supply stands defeated as such. One of the most important highlights of the Supreme Court judgment is that the recommendations of GST Council are not binding on center or state in absence of resolution to any repugnancy between Article 246A and Article 279A, which was contemplated under the draft constitutional amendment but did not find a space in the final 101st Constitutional Amendment Act. While the Supreme Court has held that the recommendation of GST Council is not binding, there are various provisions under the IGST Act as well as the CGST Act which requires recommendation to be mandatory before enacting those provisions. Thus, the principle is not completely overruled, but it has been acknowledged by the Supreme Court as well. Further, the issue relating to levy of service tax on such transaction was also debatable, and the issue is further pending before the Supreme Court itself, which will now find finality basis these judgments. The Supreme Court judgment will further have impact on the decision of Munjal Manish Bhai Bhatt relating to prescription of valuation mechanism in rules or notifications. The Supreme Court has deliberated upon this issue briefly and have held that valuation provisions do allow a room for issuance of a notification for prescribing valuation mechanism therein. And any interpretation that valuation mechanism can just be prescribed under the rules is incorrect. To this extent, the ruling of the Gujarat High Court in Munjal Manish Bhai Bhatt is overruled. However, the ruling will still sustain in light of the findings of the Gujarat High Court that when actual value is available, notional value cannot be taken. Given this is the way forward for the taxpayers to adopt, given this ruling is favorable in nature. Firstly, we must contemplate on issuance of credit notes and claiming refund for past period. This will be subject to the provisions of Section 54, that is time limit and unjust enrichment still needs to be satisfied in all cases. Further, the taxpayer can stop paying GST basis this favorable ruling. And there is a possibility of retrospective amendment as well. Further, you will observe that there has been retrospective amendment in various provisions after the court's judgment. You can anticipate that a retrospective amendment may come to overrule this judgment as well, given that the taxpayer can still pay GST and claim credit as the situation is revenue neutral. That's all from our side. Stay tuned for our next updates.